Hello class, we're going to look at chapter 38 in this video. It's a short chapter. We're going to cover limited liability companies and other special business forms. So first of all, the limited liability company is also known as an LLC. It's a fairly new entity designed by statute, I would say maybe in the last 30, maybe 40 years. All right. It is a hybrid type of entity. It takes the best of partnership and the best of corporations and combines it into this modern entity. There's a little less formality with an LLC. So the documentation that we will see when we talk about corporations, it's not always required for the LLC. So in that respect, it's a little more like a partnership. I made reference in the previous chapter to partnership and how there's no requirement that you have a writing of the partnership agreement. That's what we mean when we talk about informality of creation of the business entity. All right. Now, taxation can be done either like a partnership, so that the business will have the benefit of being taxed at only the individual partner's level, not at the business level, right? Or the other choice is to be taxed like a corporation. So it's a choice, though. For the LLC, I would probably say most would choose to be taxed as a partnership. All right. And the other advantage of an LLC is that there is limited personal liability, which is an aspect of corporations. All right. So already you can see the hybrid nature of this entity. Now, a few years ago, there was this case Hodge that was determined, and it was confirmed in that case that the owner of an LLC has limited personal liability. So I just want to take a quick look at that case with you. I have called it up here, so let's see if I can quickly get out to it. I hope I can. All right, here it is. This is in your textbook, and in this case, what happens is that there was a man who went hunting. His name is Donald Hodge here, and he went hunting. He was in one of these deer stands that are high up in a tree, and from there they shoot deer. All right. The deer stand was not probably tied down well enough. It was not strapped to the tree well enough, and it fell, killing Mr. Hodge. Now, after his death, his children sued the owner of the deer stand, which happened to be an LLC, called in this case Strong Built International. All right, there is only one member and manager of the LLC, and he argued that only the LLC is liable, that the children who are suing are not able to reach any of his personal assets. Now, that was what was determined at the trial court and then later affirmed on appeal. So this has been litigated, and it is pretty clear, all right, that the members, aside from any exceptional case, all right, they have limited personal liability. All right, I'm going to go back to the PowerPoint now. Let's see if I can do that really easily. All right, let's take a look then at formation. How do you form an LLC? And what you're going to see here is that there's a lot of similarity once we talk about corporations. All right, it is overseen by the Secretary of State's office, and the owners of an LLC are called members. All right, these are the people that invest in the LLC. We call them members. The document that is initially filed with the Secretary of State's office is the Articles of Organization. Articles of Organization, and I have uploaded that just to give you a sense of what that looks like. So let me go out and locate it for you. Here we go. All right, so if you recall, we looked at the LP1 in the chapter 37. And here's the Articles of organization. I'm just going to scroll through the instructional pages. There's several of those, and get to the LLC1. All right. So similar name to the LP1 that we looked at in chapter 37. It's set up very similarly, if you remember, right? The name of the LLC that's being registered, business address, section for the identification of the person who will receive service of process on behalf of the LLC. So if you recall, service of process are any legal documents, as in a lawsuit, the complaint. Who would you serve it to? You serve it on the individual identified here. There is an additional line here for management. You need to identify for the Secretary of State's office, how is the LLC managed? Is it managed by one manager or more than one manager, or is it managed by all the LLC members so they know who to go to, who to contact? Number 5 is a purpose statement, and you'll see it's a pretty generic statement there. The purpose of the limited liability company is to engage in any unlawful act or activity for which a limited liability company may be organized under the California Revised Uniform Limited Liability Company Act. That's already included for you. And the last section is for signature. All right, you can find this on the Secretary of State's website if you are anticipating creating an LLC. All right, I'm going to return now to the PowerPoint and let's see, return it to slide view. There we go. There. All right, now we can talk a little bit about operations of the LLC. All right, there will be an operating agreement most likely. Again, preferably, as a lawyer, I speak to you, it will be in writing. All right, it's not required, absolutely, but it's probably a better idea. It's a wiser thing to do. All right, this operating agreement will be signed by the members of the LLC. It will address, as a document, it will address issues of management, profit sharing. How will ownership interest be transferred, and if it's necessary, a buy-sell agreement. All right. You can think about this operating agreement as very similar, all right, to what we will mention when we talk about corporations. So it's very similar to the bylaws in a corporation. It will address governance issues, very much like bylaws do. All right. So voting rights. When do you have meetings for the members? How will the company be managed? All right. There are any number of operational issues you can address in this operating agreement. All right. There can be provisions as well regarding dissolution, termination. Is it done by a vote? How many have to agree in the vote? Those type of terms can be included. And the last point on this slide, if an issue is not covered by the operating agreement, then the default, okay, where do we look? We will follow principles of partnership law. So in some respects, you'll see a lot of overlap with partnership, what we learned in partnership. But on the one major aspect in terms of protection from personal liability, you'll see very clearly that that's patterned after the corporate structure. In terms of management, there are a couple of ways you will see this set up. Typically, if you have a small number of members, perhaps all the members will be involved, and we'll refer to that as a member-managed LLC. But you don't have to do it that way either. You can have a manager-managed LLC, meaning that someone is chosen, someone's designated, or a group of people, maybe a committee of people, are designated to manage the LLC's business. All right. And when we talk about a manager-managed LLC, the managers then do not all need to be members of the LLC. So you can bring in some professional management if that's what you choose to do. All right. All right. Unless you agree otherwise, though, all members are going to be entitled to participate in management. So that's kind of your default, is a member managed LLC. And these managers, just as we talked about with partners, they owe the fiduciary duty of loyalty and the duty of care that we mentioned earlier. All right. Now, how will an LLC end its business? Just as with partnerships, you could see a dissociation take place where a member is going to withdraw from participation, no longer wants to participate or act within the business, all right? And that means that it would trigger some kind of a buyout, some kind of a buy-sell agreement would then take effect. And just as we talked about with partnership, we would look to the operating agreement and see what does it say about this type of an arrangement, a buy-sell agreement or a buyout. All right. I just stuck this in here, this case in point 38.7, venture sales. It's an illustration where an LLC had to come into court to have its dispute over the valuation and then termination of the LLC resolved. And in that particular case, venture sales, the court had to decide whether to dissolve the LLC, whether the circumstances required it at this point. So just an illustration for you if you care to look at it. It just might help you. I'm just, yeah, all right. Now, last point, we are familiar with dissolution in partnership. So we remember that first, there has to be some agreement, some determination to dissolve, and then there will be a winding up. The same thing happens here with the LLC. There'll be a winding up phase where all the business transactions are tied up and assets are distributed. So I have summarized now for you on this one of these last slides. What are the advantages and disadvantages of an LLC? There's quite a few advantages and very few disadvantages here, but I've identified a few disadvantages for you. So advantages. Members have limited personal liability. The LLC may elect to be taxed as a corporation or a partnership, so you have some flexibility there. And again, it's more like a partnership in the sense that you're not required to have documentation. You have a little flexibility there. You don't have to have a written document for every decision, which you have to have in a corporation. All right, so those are your advantages. Your disadvantages, I have to think a little long and hard about this, but there could be a lack of uniformity of statute among the various state jurisdictions. So California may have certain rules regarding the LLC, and Tennessee on the other side of the country may have another set of rules. So you may run into this lack of uniformity, and that may cause you some problems when you're operating a little more nationally as an entity. And going beyond our national borders, the LLC is a fairly new entity under our laws, and you just may not find it. You may not find it recognized in all jurisdictions around the world. So if you have any kind of desire, to go internationally, and it's not unusual here in California since we look to the Pacific Rim, and we do a lot of trade with Mexico, right? Those two places, may not recognize the LLC as a form really well. So you may want to choose a different business form instead of the LLC. But, again, think about it, think about where you plan to be in the future, and, see what's best for your business at the time that you get yourself set up. All right, the last part of the chapter. What we're going to look at here are a few special business forms. So I've already mentioned to you, if you remember earlier, the joint venture. The joint venture is basically a general partnership, The way we differentiate a joint venture from a general partnership, however, is to say that a joint venture is usually formed for a specific period of time. So they may put a very short period of time on it, a year, all right? And that's as long as they're going to stay in business, and then after that it will dissolve. But the way I have seen it, and I know my experience is many years ago now, but I would think it's a little easier to think about a project. So a group of people could come together to buy a piece of real estate, let's say, and decide that they will hold it and just flip it. All right. So that would be kind of short term. Joint venture suits them. All right. So whenever the project is finished, whenever the duration of time is over, that's when the joint venture dissolves. So that's how we use the term joint venture. But other than that, just think of it like a general partnership. All right. All right. The second type of special business form is a syndicate. Now, syndicate is not a form in the sense that you go and file documentation to say you are a syndicate. You do not have an agreement. That the way I've talked about it with a partnership, or here that we even looked at with an LLC. It's a more informal term, all right, that a group of people come together, or they want to finance a project together. We call it a syndicate, all right. They can choose any business form they really want, and they can just call themselves a syndicate. So you could actually be a partnership, but instead of using the word partnership, you call yourselves a syndicate. All right. So they don't have to choose any form. They could just kind of loosely be joined together in business. All right. So this is why syndicate kind of flows a bit and kind of comes together with partnership, because partnership can be very informal. All right. But it is a separate concept that's apart from partnership as well. All right. So syndicate. Right. And our third and final special business form is the cooperative. Right. A cooperative is an association of people. Usually we might refer to them as members. All right. So there's an association, and they organize themselves to provide an economic service without making a profit. So, good example of this is a credit union. All right, which operates for the benefit of its members that join so that they can have banking services that are provided basically at cost to them. They're not paying extra fees for that, because they have already joined this group. So unions often will set up credit unions, big unions, big working labor unions. What can set up credit unions? I noticed that. As a teacher, as an instructor, there's a credit union called Schools First, all right, and I can join that, pay a nominal fee and join that, and have some banking services through the Schools First credit union. All right. Now, the credit union can be incorporated as well, all right, but if it kind of keeps this idea of providing an economic service, not generating a profit, it will be fashioned after the cooperative that we are looking at just briefly here. All right. So this now brings us to the end of chapter 38, and I want to look at a problem with you. All right. So I have it already transferred from your textbook to a slide. It's the reviewing problem at the end of the chapter. It's a little longish, so let me just read through it with you. All right. The city of Papagos, Arizona, had a deteriorating bridge in need of repair on a prominent public roadway. The city posted notices seeking proposals for an artistic bridge design and reconstruction. Davidson Masonry, LLC, which was owned and managed by Carl Davidson and his wife, Marilyn Rowe, decided to submit a bid to create a decorative concrete structure that incorporated artistic metalwork. They contacted Shana Lafayette, a local sculptor who specialized in large-scale metal creations, to help them design the bridge. The city selected their bridge design and awarded them the contract for a commission of $184,000. Right, so Davidson Masonry and Lafayette then entered into an agreement to work together on the bridge project. Davidson Masonry agreed to install and pay for concrete and structural work, and Lafayette agreed to install the metal work at her expense. They agreed that overall the profits would be split, with 25% going to Lafayette and 75% going to Davidson Masonry. Lafayette designed numerous metal sculptures of trout that were incorporated into colorful decorative concrete forms designed by Rowe. Davidson performed the structural engineering. The group worked together successfully until the completion of the project. Using the information that's been presented now in the chapter, we're going to answer the following questions. All right, number 1. Would Davidson Masonry automatically be taxed as a partnership or a corporation? All right. Now this has been worked through through the IRS. I would say maybe 20 years ago. All right. Right. So as an LLC, Davidson Masonry would be taxed as a partnership. So that means they're going to pay taxes only at the individual level. So the artists, Rowe and Davidson Masonry, they and the owners of Davidson Masonry, they would pay at their individual levels. All right. Number 2, is Davidson Masonry member managed or is it manager managed? All right, it is member managed. The 2 members of it, I don't recall their names off the top of my head, but they are participating and they make the decisions for Davidson Masonry. Right. Number 3, when Davidson Masonry and Lafayette entered into an agreement to work together, what kind of special business form was created? Oh, did I get her name? I must have recalled it wrong. Okay. So anyway, they formed a special kind of business there. Can you recognize it? We have just talked about it. It's the joint venture. All right. It's a project-oriented partnership. And so when they are finished with their project, it will be dissolved, their partnership, so to speak. And so we will refer to that as a joint venture. All right. Last question, number 4. Suppose that during the construction, Lafayette entered into an agreement to rent a space in a warehouse that was close to the bridge so that she could work on her sculptures near the site where they would eventually be installed. She entered into the contract without the knowledge or consent of Davidson Masonry, which is her partner. All right. In this situation, would a court be likely to hold that Davidson Masonry was bound by the contract that Lafayette entered, and why or why not? All right. Now, the joint venture, it operates a lot like the general partnership, right? It operates just like it. So Lafayette entered into this agreement in furtherance of the joint venture's business. She does have authority as a member or as a partner in the joint venture, right? She can bind the partnership. And so, yes, we would answer this, yes. Davidson Masonry will be liable because Lafayette can bind the co-partner. They each can bind the other here. And so we're looking at what she has done. She definitely can bind Davidson Masonry, and so they both will be liable then on the commitment made under the contract. All right, closing out then, and we will pick up later with the next chapter, chapter 39. All right, I'm going to be closing out.